I want to just give a brief opening. I'd like to welcome you all here. First of all, thank you for attending and showing your interest and support for the furthering of the Belize real estate industry. I'd like to welcome you all specifically to this first of its kind open discussion on the Belize Real Estate Bill webinar put on by us, the Belize National Association of Realtors. And I'll give a little bit of history about the association shortly. But before I do that, I just want to acknowledge all our guests. First of all the professionals and associates from related industries that have seen the need to participate and make sure that this bill goes through in a manner that is transparent and agreeable to all. But I also want to acknowledge too some very special government agencies who have made the effort to sit in and to take notes, because these things, will affect all of us, including the government. So I'd like to thank personally the Ministry of Natural Resources, specifically the Lands Department, who are also sitting in on this right now. I'd also like to personally thank the FIU, who are also sitting in and taking notes, and also Central Bank, who are sitting in and taking notes. So your support for the industry really means a lot, and I think that you guys will get a good insight into what is happening with the industry and where it is going. So with that said, I want to just give a little bit of history about the BNAR. We were formed in 2006, and at a certain point kind of went dormant. But the industry keeps calling, and there's things that need to get done, including this bill. We could not stand by idly while nothing was happening. And this is really a key piece of legislation for the industry, and it should ensure a higher level of prestige and actually just better experiences for buyers and sellers, not to mention the government collecting tax, right? So everyone should be pretty happy with this legislation going forward. With that said, I just want to mention that this is covering a few of BNAR's goals, which we have 3 tenets, which include education, advocacy, and networking. And as you can see, we're here, we're networked, we're advocating, and this is going to be very educative. And I hope that you guys really take some notes, and you will be able to ask questions. I just want to give this very quick spiel, is that what we'll do is the format is going to be such that we will have the presentation by the attorneys at law, who I will introduce shortly. And people who want to ask questions, you will have to type them in the chat, and we will then go over those questions afterwards in a Q&A session and answer them one by one pretty much. So we want to allow our presenting attorneys the space to finish all of their thoughts. And from that point, we will then take questions afterwards. After that, we will actually close, because in the essence of time, we don't want the whole thing to go over much more than an hour. But for people who are very concerned, I want to continue voicing their concerns, asking questions. We will have an open session afterwards where it will be left open for discussion. So if you want to hang around, you can. And if you don't, then we're going to try to wrap this up essentially in around an hour. And I'll have the attorneys explain a little better to you. So I'd like to, again, just thank you all for being here. I'd also like to thank and present our presenters and facilitators, Mr. Wayne Piper and Mrs. Oneyda Flores Piper. They have been instrumental. They'll give you a little bit, well, they'll give you a lot more right now, but I just wanted to introduce and thank them. Without them, this is not possible, and we do appreciate them at the BNAR for helping us, our members, and really the industry at large to better understand what's happening and how we need to move forward, right? So with that said, I'll turn it over. Remember, guys, we're open. Put your questions at the bottom, and even after this is all over, please feel free to email us at the BNAR with any more questions or concerns that you may have, and we will be happy to answer them. And also, if you'd like to be a part of the industry and help drive it forward, we'll be happy to have you as members and have you on a subcommittee. So we need all the professionals on board to make things happen, right? So with that said, I'll turn you over, but I just wanted to mention one more thing about the bill, because it's something that we've been getting a lot of emails about and calls, text and so forth. And I want to clarify something. This bill is nowhere near final. In fact, if you notice, it has a 2016 draft on it, being that that's how long it has been sitting there. But this bill has also gone through many different incarnations for around 15 years or a little bit more, right? So don't get alarmed at the content of the bill. We are here to explain the bill and also explain what is necessary in the bill, well, through our attorneys. So this is the first. So please understand that your comments mean so much to the passage of this bill, but it's by no means final. And that is why we're having this discourse right now, is to make sure that we're all totally cool with this bill, right? So with that said, the bill's come a long way, has a long way to go. I will now finally turn you over to our presenters and attorneys at law, Mr. and Mrs. Wayne Piper. These guys take it away.
Thank you.
Hi, everybody.
Hi, everyone, and good afternoon. Thank you so much, Carlo. As Carlo has started by introducing the bill itself, you'd all note that he said it's a 2016 bill. And that means the last time that this bill was actually touched was probably 4 years ago, if not more. What that ends up causing is that time has probably outpaced this piece of legislation. Neither Oneyda and I had any hand in drafting the bill itself, but we've been trying to work very hard with the association to understand what the provisions of the draft mean for you all as real estate professionals. And there are elements of it that we agree with. There are elements we strongly agree with. There are also elements that we've advised we need a lot of work to go into this bill. So what we're going to try and do in our presentation today is to really pick out the key elements to explain to you as professionals how this bill will impact you directly, how it may change your practice, and how it may improve overall being a real estate professional in Belize.
Yes, we're going to share a PowerPoint presentation now. All right, so Belize Real Estate Bill 2016, a working draft. So what we want to first of all start with is talk about why we should have a real estate act or real estate law, and how it would benefit you as professionals, as real estate agents, brokers, salespersons, attorneys, and so on. First of all, it would basically set a standard for the profession. It would have rules and regulations in relation to how the profession should be conducted. The real estate industry in Belize would operate at an international standard of professionalism, which means that the type of clients that you get and the visibility that you're going to get will improve greatly, because you would be certified and licensed, and there would be significant accountability. So clients would be more comfortable hiring you as a broker or real estate broker, salesperson, because of that. Another benefit or another reason would be that all the agents would have equity. Everybody would come in on equal footing, as you would have to go through the same process for qualifying or for becoming licensed as a broker or salesperson. With that comes sanctions and disciplinary actions for misconduct towards the profession and towards clients. So it is important for the profession to have in place the regulations governing its affairs, including ascertaining that only qualified persons would be permitted to engage in the provision of real estate services. Again, like I said, it would set the regulations for the profession and sanctions and disciplinary actions. The most important aspect would be that you would have the greater trust with your client base, which would lead to more investments, more referrals, and that comfort knowing that you're certified and you're qualified to provide this service, and that there are recourses for the event that there is any sort of misconduct or any issues with the specific realtor. We'll now discuss in terms of what the practice of real estate business is, and I'll ask Wayne to go ahead to go over that with you.
Before I say anything further, I'd just like to raise for you all what we are doing. Everything we're discussing right now comes from a specific section in the draft legislation, but we are trying to break it down in a way, cut out a lot of the legalese that is there, and try and put it in as plain language as possible. So especially what you're seeing on the PowerPoint is not the legalese necessarily that's in the act, but our interpretation as to what's coming from it. What is key for you all today is to understand how this will impact you directly. And the first thing to note is who exactly or what exactly is the practice of real estate business. And this piece of legislation is not narrowly just considering real estate brokers, real estate agents. It is very wide in who it captures as actually practicing real estate business. So what it does, it lists the components or the key elements that if you meet those elements, you'll be considered as practicing in the real estate business, and thereby you would need to be licensed or regulated under this new piece of legislation. So the first key component is if you are working for compensation, so money or other consideration. So if you are doing real estate business but for free or for charity, you would not necessarily fall under this act. And if you are for compensation, now auctioning, selling, exchanging, buying, leasing, or renting real estate. If you are advertising or holding out that the public, that you are engaged, holding out to the public that you are engaged in auctioning, buying, selling, exchanging, leasing, or renting land, or negotiating the auction, purchase, sale, exchange, lease, or rental of any land. So you'd see here that it's not just limited to the listing for purchase or sale of land or property. It also involves leasing, rental, and also goes as far as extending to auctions. So if you have persons engaged as auctioneers, once they're auctioning land, they would also fall under this piece of legislation. Also, if you're managing land or engaging in any other business concerned with the management of land, either in a consultative capacity or an agent, you would also be considered to be in the practice of the real estate business. Or if you're taking part in the procuring of sellers, purchasers, lessors, landlords, or tenants of the land. So you don't have to also just be engaged in the active listing or sale. If you are just trying to procure the seller or the purchaser, you'd be considered in the practice of real estate business. If you are managing land or engaging in any other business concerned with the management of land, either as a consultative capacity or agent, takes part procuring sellers, purchasers, again, we're just listing the key elements, directs or assists in the procuring of prospects or negotiation of closing of any transaction which results in a sale, exchange, lease, or rental of land to another or of another is calculated to have that result. Now you'd see that there are a wide range of elements that would have you fall under practicing in the real estate business. However, the act or the bill as it is right now, it has envisaged some exceptions to those wide-ranging criteria. And the first is where a person is acting under a valid power of attorney for the purpose of negotiating or executing contracts, transfers, or conveyancings in respect of interest in real estate. So if you are under a power of attorney, not being an attorney at law, but if you get the physical document being a power of attorney from somebody to act on their behalf, you're not being seen as engaging in the real estate business. But as many of us would know, the power of attorney has certain formalities, whether it's dealing with registered land or unregistered land, you must meet those formalities for that power to actually be valid. The next exception is where an attorney at law giving legal advice and services ancillary to or in connection with the real estate business. So an attorney such as Oneyda or I, in our practice, that is giving legal advice to a client that is connected with the real estate business would not be seen as falling under this piece of legislation. The draft bill as it is has certain provisions that we as attorneys are very concerned of because it seeks to amend what we see as being the practice of law. And we think the bill will need some work before it can actually get through without great opposition from probably the Bar Association and the wider legal fraternity. But at the same time, we understand that there must be some boundaries between real estate practice and legal practice. But as it is right now, attorneys at law within their legal practice, giving legal advice and doing real estate business, say conveyancings, drafting sales documents, and actually handling sales and transfers, that would be outside of the ambit of this legislation. Another exception would be an officer of the court acting under or in pursuance of a judgment or order of a competent jurisdiction. So I'd say, for example, a court marshal who has been ordered to assist in the sale of a piece of land or doing anything with land would not be deemed to be practicing real estate business, and as such would not fall under this bill. An administrator, executor, receiver, or trustee also would not fall under this bill where they are actually properly appointed. So if you are dealing with land under a will or under a grant of administration, you would not be falling under this act. You'd be dealing with it in your power as an administrator or executor. Where you're dealing with land also as a part owner or shareholder. So if it is your land, you're not doing it as a real estate professional. If you have shares in the company that is trying to buy or sell a certain piece of land, you are not doing it as a real estate professional. And as such, you don't have to be licensed and regulated under the legislation. Also accepted from the regulation would be a public officer acting in the course of his duties. So again, this may be somebody who works in one of the ministries or government offices that has to do something, whether it's in relation to private land or government land. You would not be falling under the restrictions or requirements of this legislation. They would not need to be licensed. They would not need to pay their fees. They would not need to meet the educational requirements. Finally, where the person is employed or acting in the capacity of a manager of a strata complex, carrying out duties in relation to the renting of individual units or within that building complex or complex. So if you're a manager in a strata complex, you'd be expected to not only manage real estate, but also to seek out tenants. And you may do that without getting a real estate professional. And in doing that, you would not be coming under this legislation because you'd fall under one of the exceptions. Okay, I've just listed this slide. I've reviewed them again, so it will give you all a chance just to see quickly again. These are all the exceptions. So again, we're acting under a power of an attorney at law giving legal advice or services, an officer of the court, an administrator, executor, receiver, or trustee. We're dealing with the land as a part owner, public officer acting in the course of his official duties, or a person employed or acting in capacity of a manager or of a strata complex. All of these persons acting in these duties would not fall under this piece of legislation because they're protected by the exceptions.
Okay, so now we will discuss who will oversee or who will regulate or enforce all these regulations and all these obligations that the industry will have that is set out in the legislation. The act envisions that there will be a commission. There will be a commission or a board established that will regulate and control the practice of real estate business. One of its key functions will be to promote the sustainable development of the real estate industry in Belize, as well as to ensure compliance with the laws and regulations governing the real estate industry. So it will have, according to the legislation, or in accordance with the legislation, it would have the power to consider applications and granting of licenses for real estate brokers and salespersons, renew those licenses, and take disciplinary actions for breaches by licensed real estate professionals. It will also have the power to appoint disciplinary tribunals to hear these complaints or these actions for breaches. Currently, the legislation has set out the composition of the commission. The composition currently being not less than 5 and not more than 7 members appointed by the minister from among persons appearing to the minister to have ability and experience in matters relating to the real estate industry. Among those would be the Commissioner of Lands and Surveys, the Chief Valuer in Lands and Surveys, and not less than 3 and not more than 5 other members appointed by the minister on the recommendation of the association. That is currently what is set out in the bill, but there is room for, depending on what the professionals and what you all would think in terms of how the commission would be constituted. There's room for modification there. That being said, we will move on to who is a real estate broker and who is a real estate salesperson. What is the difference? So a real estate broker is a person who, on his own account, engages in the practice of real estate business, whether as a sole proprietor of the business or not, or an individual who is a member of a partnership, a director of a corporate body that itself engages on its own account in the practice of real estate business. Whereas a real estate salesperson is an individual who engages in the practice of real estate business in whole or in part as an agent, sub-agent, or independent contractor of, or is subject to the direction, supervision, control, or management of a real estate broker or developer. Just a minute. Sorry, I'm having a little bit of technical difficulties with the slide. Seems one of my slides is missing, but I'll move on. So we'll actually get to what are the requirements for you or for a person or for an entity to become licensed or registered as a real estate broker or as a real estate salesperson. An application will be made with the commission for approval, and the requirements are that the person is a fit and proper person. In order for an applicant to qualify for licensing as a real estate broker, he must meet the following qualifications, or a salesperson. First of all, the person must be of sound mind, in possession of a clean police record from his native country or from Belize, once living in Belize for an uninterrupted period of 6 months or more, must not have been convicted of a felony in any court of law, whether it's in Belize or elsewhere, must be a Belizean citizen or in possession of valid work documents, and must have obtained adequate training in the real estate profession and is suitably qualified and competent to practice real estate. Now, there are further requirements as it relates to brokers. Apart from those that I've already mentioned, a real estate broker must have the following additional qualifications. He must have actively worked as a licensed real estate salesperson in Belize for no more than 36 of the previous 48 months, and must have obtained adequate broker training and have passed a broker's license exam. So there is quite a hefty requirements. There are quite hefty requirements in order for you to be licensed and qualified. I do believe it needs to be a little bit more specific, but I guess we can discuss that afterwards in the Q&A if you have any questions in regarding to that. So we can go on to discuss disqualification. So if you qualify and you get licensed, or if you don't qualify, these are the individuals that are not eligible for registration or license as a broker or salesperson. You do not possess the qualifications which I have just mentioned. You're under the age of 18. You have been adjudged a bankrupt, and the order that was made against the individual remains undischarged. That you have been convicted of an offense under this act or in respect of property involving fraud or dishonesty. Now, in terms of offenses under this act, we will discuss that in a later slide. So in terms of entities or companies, partnerships, and so on, that a resolution has been passed or there's a court order to wind up the company, any proceedings taken where its property may be distributed among creditors, where there is a receiver appointed for any of its property, where there is at least one director that is not qualified for registration, any director otherwise disqualified for registration as an individual, or one or more director has been convicted of an offense under the act or in respect of property involving fraud or dishonesty. So based on what the provisions for disqualification are, it is not expressly stated, but from this we can gather that all directors of a company must be licensed and registered in order for that company to be registered and licensed as a broker or salesperson. So another very, very important and key element of this piece of legislation and the why is the handling of clients' funds. This is going to regulate, and this will regulate how you as a real estate broker or salesperson handles your client funds. So money is received by a broker or salesperson who holds that money will hold that money in trust for the person who is entitled to cover it for your client, whether it's the purchaser or the seller, if it is received by him as a stakeholder, is held by him in trust for the person who may become so entitled on the occurrence of the event against which the money is held. Such monies held in trust will not be available for payment of any debt or liability of the real estate broker or salesperson other than the person to whom he holds the funds for. So if the company goes into liquidation, or there is a court order or a judgment debt against the individual or the company, those monies that are held in trust for the seller or purchaser will not be made available to the judgment debtor, basically. So that will not form part of the person's estate or part of what is available for creditors, other than for the person to whom it belongs. So another aspect is that agents will be required to keep clients' account. So you will, every broker, salesperson will have to have a trust account at a bank. That trust account would have to have the word client account, escrow account, trust account, holdings account, any of those words that would identify the account as not being for their personal use or their business use, but for the purpose of holding client funds. The broker or salesperson will be required to keep record and accounting of those funds, so that at any point in time, if the commission determines that they need to do an audit on the agent's business, the agent would be able to show an accounting of what is their fund and what is their client fund, separate and apart from each other. Okay, so that being said, we'll discuss now the code of conduct for real estate professionals. Wayne?
The draft legislation as it is, the bill has inserted a code of conduct for real estate professionals. We have some concerns with both the placement of the code of conduct in the middle of the piece of legislation and how it is worded. Again, I guess this bill has been through so many versions over the years that sometimes when that happens, it can look like a cut and paste job of where things are put in. But we agree a code of conduct is very necessary and very useful for professionals. As attorneys, we have our legal canons and our legal code of conduct. And similarly, this piece of legislation tries to encapsulate how real estate professionals should handle themselves. And when we're using this code of conduct, it would be the guide that any disciplinary tribunal will use to figure out if there was a breach. Now, I've just tried to pick out some of the key elements. The code of conduct is quite long, it's quite lengthy, and it may need to be condensed going forward. But I've tried to pick out some key elements as to what it is trying to get across for the conduct of a real estate professional. The key thing with the code of conduct is it is trying to outline the duty of a professional to your clients, your customers, and also to the public at large. The first thing to consider is in the canons, in the code of conduct, it specifically states that the real estate professional shall not mislead the owner as to market value. So as real estate professionals, and I think I'm right in assuming that everyone who is here with us today is an upstanding, very forthright professional and will not mislead. But we're also in the sales game, in the game of selling and marketing properties. But we must always make sure that in selling, in trying to market, in trying to put forward these properties, we don't act in a way that misleads the owner as to the true market value. This statement also assumes that as a professional, you have a certain level of knowledge. You may not be a valuator as a real estate broker or real estate salesperson, but you must be speaking as to the market value or sales value or rental value of property. Be speaking from a place of some knowledge. The second point is you shall not mislead buyers or tenants as to the savings that may be realized through the use of a broker. So if you know in your heart and in fact that there's no added value to be using a broker for the purchase or the rental of a property, it would be a breach of this code of conduct to sell it or upsell it to a buyer, a potential buyer or a potential tenant, that by using you as a broker, there is some benefit. There must be some actual benefit if you're going to say this. It again goes to misleading. Third point being, where representing both parties, notice must be given. And not only notice must be given, but the legislation, the code of conduct, requires that that notice be given in writing. So we see it's common practice very often that where you're acting on behalf of one party, you may end up acting on behalf of both. It may be economical, where a party does not want to, or two parties don't each want to pay an agent. But what this gives rise to is a potential conflict of interest. So this must be brought to both parties from the start. And it must not just be brought by saying it. You as the professional now must put that in writing, because if you end up before a tribunal, they're not going to take your word on you said it to both parties. You must have a document and you must show that it was delivered to both parties. The fourth point is that offers and counter offers must be submitted as quickly as possible. Again, you don't wish to be in a situation where one party loses a sale and you're accused as the agent of holding back their counter offer or their offer to allow another offer to get through. You need to, as quickly as possible, get all of your offers communicated. The next point, you shall continue to submit offers and counter offers until closing. This is to avoid a situation in practice where you might get an acceptance. The owner of the property may have said, okay, I accept this offer, but the duty of you as the agent is to continue communicating offers or counter offers right up until there's closing. Just because you have an acceptance of an offer does not necessarily mean it's going to successfully close. Everyone possibly has gone through situations like that. Under this piece of legislation, you could actually find yourself in problems with your disciplinary tribunal if after you have gotten an acceptance, you did not continue submitting the offers that came in. Having spoken about the actual code of conduct itself and the requirements, the very strict requirements therein, we would definitely also have to speak of the disciplinary side of it. The legislation, on top of having set up a commission or considering having a commission set up, and that commission now determines whether or not you get licensed, whether or not your license gets renewed, and any disciplinary requirements with relation to your license. The legislation also provides for summary procedures and summary penalties, which now this means that the tribunal itself or a third party, being somebody you represented, could now bring you before the court on a summary charge for practicing without a license, carrying out the business with an intention to deceive. And what this may mean is you may have if you're not a licensed real estate professional and set up your company as Company X Real Estate Brokers, then you are setting up a real estate and business with the intention to deceive the public to believe that you're a licensed broker. Knowingly makes false or misleading statements, which goes back to those strict requirements in the code, or holding office while disqualified. Oneyda spoke about the requirement that if you are a director or an officer in a company that is a real estate company, if you stop being a licensed real estate professional, you can no longer hold an office in that company. The draft bill also sets out what some of those penalties are. And as you'd see from this slide, those penalties may seem slight, but some are not. If you are after you've been convicted of an offense summarily, there's a penalty of $100 for every day the offense continues after that conviction. At the time of conviction, you may also be subject to a fine of up to $5,000. or imprisonment up to a term of not exceeding 6 months. I'm sure none of us here want to be subject to any of these penalties. Thank you so much for your time and attention. We've tried to make this as short and as simple as possible, cutting out a lot of the legalese, but I'm sure a lot of you have questions, and we will be here to answer any questions that you've submitted so far. And also, I'm sure through the association, if any questions are submitted at a later date, we will also be available to try and answer those as best as possible. Thank you.
Thank you.
Thank you, guys. We have actually collected quite an amount of questions, which we have been taking note of, and some of them fall into similar categories. So I think we can kind of start with them kind of from the top. And I don't want to leave anybody out, but I do know that some of them also tend to be around similar topics, and I can tell that a lot of them have to do with the requirements, but also the commission. So I want to take the time again, everyone, just to note this document. Actually, we had received this document a couple months ago, and we had already given quite an amount of feedback on many of these items that are now seeming like hot button type issues. So I want to let you also understand that we kind of already agree with a lot of the stuff that's coming in the group. And we have already submitted to Land Department our concerns that we had canvassed from our members. So a lot of what is being said in the comments are totally understood. And I want to put people's mind at ease again, if you were late. This is a draft bill. It's an old draft bill. It's a draft bill that is actually originally based off a Jamaican bill from like the 80s, if I'm not mistaken. Oneyda and Wayne, I think it's the 80s.
Yes, it has not been updated to reflect what the current legislation is for Jamaica, if that's what the legislators wanted to model it from. So it's as we said, it's a working draft. We did not draft the bill. There is a lot to be modified, a lot to be modernized. So yeah, we welcome the questions and see if we can answer all of them.
Yes, and the bill itself is outdated. I do think that the Jamaican legislation has far outpaced where this bill is right now, because I actually looked at the Jamaican real estate board's requirements, and they've actually moved on. A lot of they've joined their strata commission with their real estate board, and now in their real estate board, apart from general real estate concerns, they also have to deal with FIU concerns, anti-money laundering concerns, all within that. I know a lot of the concerns that I'm seeing really have to do with development and developers. And from our discussion before, Carlo, it seemed the specific provisions for this draft bill that related to developers was pulled out. Mm-hmm. But it was pulled out without actually addressing the concerns within it. You can't just take a draft piece of legislation and pull out a section that deals with developers with the intention of protecting them, because what it actually does is it makes them fall into a loophole where are they needed to be licensed or are they not? Mm-hmm. And if you're saying they need to be licensed, you're sort of putting very onerous restrictions on developers that you didn't intend to by trying to pull them from the legislation. So I think what the legislation probably needs is to have a section in it that actually speaks to developers and what their requirements are.
I think that's one of the questions that Michael had. He says, how can this act regulate development companies? By doing so, you change the tax liability of development companies, and due to restrictive licensing qualification criteria, disqualify developers from being licensed. This will chase away foreign direct investment. As we said, it doesn't really speak to developers and what the criteria they would need to be licensed as well. And that's something that, as Wayne said, was pulled out of the Jamaican legislation. And that is actually something that we had looked at and recommended that there be a section in there specifically speaking to developers and how they would also be regulated and so on and so forth. So,
and it's not necessarily regulated, but regulated or accepted.
Mm-hmm.
It doesn't necessarily mean that we're saying that developers need to fall under the regulation and the licensing. What we're saying is there needs to be a provision that says how developers would be treated. Mm-hmm. And then the feedback from the association and from all the wider community sort of tells the drafters, it's not necessarily us, we'll try and assist as much as we can, but tells the drafters how developers need to be treated to make this beneficial to the Belize real estate business.
Yeah.
Thank you for that, guys.
Yes.
And yes, just to iterate the point that this was, again, based on older legislation, but with some sort of key subtractions and additions throughout the years that, quite frankly, I don't know if anyone can really explain, but I guess with different hands came different changes. We're at this point now where we're trying to kind of push this thing forward finally, because as you guys had mentioned, Wayne and Oneyda earlier, this only leads to more prosperity for the industry, really. It only raises the profile of everyone, makes it safer for buyers, sellers, and professionals to conduct business. So with that said, again, I just want to mention to everyone, this is a draft. It's a very old draft, even older than 2016. But precisely the reason we're here is because the voices of people like you, the professionals and stakeholders, are what actually will be shaping this going forward. To answer basically a question that was asked, I think, by Michael earlier, right now we have a partnership going between the associations as well as the lands department, who have basically pledged their support to us. The FIE is also behind it, and we're getting the AG's ministry into it as well. So it is something as a collaborative effort, private and public sector and across industry stakeholders. So this is why it's very important for you guys to understand what's happening, so you can then give the feedback that we can then use to incorporate. And actually, I'm very happy to report that, as I mentioned earlier, Land Department is taking notes. So all of your concerns are duly noted, not just by us, but by the relevant government agencies who are actually in their own way regulating our business, right? So with that said, I want to just mention one other thing, is that this will actually be, it's recorded, we will be sharing it, but also we will be compiling a report based on what was said by Pipers and also what we have been getting question-wise, and then we'll be answering those questions. So we'll be circulating a report as well next week, along with the actual webinar that you can rewatch if you want to understand better any point. I'm going to ask just on behalf of the group, because I saw a couple of different questions regarding the commission. I think one was asking about terms, and I think the other one was asking about discipline. Let's see. But one was asking about the terms. But I think to make that easy, I can't see it, but it was regarding the commissioner. But I think if there's a misunderstanding, that commissioner is actually the commissioner of land. So that person would only change if that position changes in land. As it's currently constituted, there's the commissioner of lands, and then there's the head evaluator as well, and then everyone else is appointed. I've been getting a lot of by the minister, exactly, which is pretty standard in our legislation, so I understand why that's there. At the same time, I have been collecting a lot of feedback from our members and just general industry stakeholders and even legal people that it would behoove the industry to have as many private sector representatives as possible. So for us, we obviously want to keep the government representatives because they also have a stake in this and they need to see what's happening and they can make changes. So it's great that they're on the board. But it would probably be better if we had a chair from the private sector and if we had much more seats from the private sector so that we could essentially more self-regulate. Right?
Exactly. Yeah, that's one of the recommendations that we had to for example, have the president of the real estate associations or the association be a member of that commission automatically, along with other members or other persons elected by the associations or by the professionals themselves, that way everybody in a way is on the same, with the same mind, with the same thought of who they would prefer having regulate or govern the commission. It is important, yes, to have the government agencies to be part of that commission. So, but I do think that there is room for improvement in terms of how the commission is constituted, how it is managed. So I think you had said that they were asking about, one of the questions was in relation to the term. It says here that the persons on the commission, on the board, would hold office for a period not exceeding 3 years. So up to 3 years, every 3 years, there would be a new commission. But those members would be eligible for reappointments, if anything. So, but yes, there is room for improvement for the constitution and how the commission is managed.
Okay. We have some new questions coming in. I just wanted to quickly, and I think I can answer this one, because we have some foreign associates and obviously foreign interest in our country. One question was asked, well, how would we deal with inbound buyer referrals? But I correct me if I'm wrong, Oneyda, I don't think that this would preclude any foreign buyer referrals, in the sense that once they're working as a licensed agent here in Belize, they can then simply send that referral money out after the deal is closed to a licensed individual in another country, right?
Well, our legislation would not be able to regulate anybody outside of
this bill wouldn't impact on that kind of relationship. That kind of relationship would be more governed by the central bank requirements and any tax requirements, whether the income tax department considers that money earned in Belize and whether any percentage is taxed before it's sent out, and whether central bank would require income tax clearance before they transmit the money to funds. But this legislation wouldn't change that kind of relationship. What this legislation would change is if that overseas agent now comes to Belize and is advertising themselves in Belize as a real estate agent. What they're saying then is that that agent would now have to meet our local requirements. They may already, with their US qualifications, they may be overqualified based on but they would still have to submit an application to the commission and pay the fee and get licensed here.
Good afternoon, Mr. Habet. I'm not sure if you're hearing me.
Yes, you have a question? You can go ahead. We were doing it in the chat, but if you want to go ahead and ask, go ahead and ask.
Okay, no, it's not a question. I just wanted to say, so my name is, for the other participants, my name is Nicola Cho. I'm one of the legal counsels at Natural Resources. Yes, I just wanted to say, I need to leave now, but thanks for the invitation. And I just wanted to add to what you've said, that this document is a document. So the Ministry of Natural Resources has been approached by Mr. Habet, the association he represents, as well as by Ms. Neal, the association that she represents. So we were approached with this 2016, or what you all are calling the Real Estate Bill 2016 draft. So they shared that with us because he's correct. For many years, we've been approached by persons in the real estate sector asking or suggesting or indicating the desire for regulation. And most recently, again, they approached us and they provided us with this document that I believe a previous form of the association or a previous group of realtors had put together. So they gave it to us again most recently, and we're looking through it. Of course, we will have our own views as to what the content of the regulation or legislation should be, and we will share that with you all. And after this meeting, if you have more to add, which you're already saying, Mr. Habet can share that with us, because we're still going through the draft that you had sent, because we had asked them when they approached us, we had asked them, can we have some indication that the people who are in your association have reviewed the document and what is their input. So they did that, they gave that to us, and that's what we're looking at. And you're always free to add more comments, your groups, because like I said, we're still reviewing what you all had submitted to us. So this document, it was, like I said, something that was put together by some previous group of realtors or persons practicing as realtors. And most recently it was shared with us, and we're looking at it because we also have a view that there should be some sort of regulation of the real estate industry. So thanks very much for the invitation. And I guess you said you would prepare a report and you share it with us as well?
Yes, certainly.
Okay, so hopefully we have we can get back to you and Ms. Neal maybe in, we had said what, June, July? I don't remember
Sure,
from the
yes,
last,
yeah.
we had said mid this year, so hopefully we will get back to you with our feedback by maybe July.
Okay.
But yeah, thanks very much for the invitation, and I look forward to the comments from this meeting so that I can, incorporate those in my deliberation and our review.
Of course, and thank you actually very much, Ms. Cho, for your time. It really means a lot, the fact that you're here with us, and that you and the department, have shown the willingness to help us with this cause. It really means a lot, and we really appreciate it. So thank you very, very much, and the land department as well. And please give the CEO my best and also my thanks.
Yes, all right, thanks very much. Okay, goodbye.
Thank you. Bye. Have a good evening.
Same to you.
Thank you. I see we have a lot of, the questions are actually piling up at this point. I think that only in the essence of time, we might not have the time to do all of them, but if you guys are reviewing the chat, do you see anything particular you want to tackle that are coming up? I see some of the things that are not related just to the bill, so I don't want to answer every question. I see there was still some, one thing about the for sale by owner. Technically, it's, I think, as Wayne had mentioned earlier, if you're doing a for sale by owner transaction, you do not serve as a real estate agent, and so you do not come underneath the Real Estate Agent Act, right? Am I correct, guys?
That's correct.
You're an owner of the property. Okay, so you don't have to worry about that. And again, guys, I see a lot of the concerns have to do with the things that are currently in the bill. But again, that's why I mentioned that there's a lot of room. And actually, Ms. Cho, the legal counsel from the land department just now, chimed in to let you guys know indeed that they are committed to this with us. And basically, guys, it's as engaged as we want to be with this. So this is an excellent start. I really feel encouraged, and I think we can really push this thing forward once we have the engagement of stakeholders like yourselves. So with that said, guys, do you want to tackle maybe one or two more that you see popping up here?
I don't have any difficulty with us trying to go through and get as many of these questions as possible that we can. You want to start, or you have any?
You go ahead with me.
I know we had looked at the first question in relation to development companies. I see the second question was from Oscar Romero, saying that the bill is very wide in relation to the persons that will be regulated. He actually says it's too wide, and some investors may not qualify. To that, what I would say is that, again, the bill, what you're speaking of as being investors may be what you call developers. And we really need to look again at the bill to see where provisions can be inserted to deal directly with developers or foreign direct investors. And the feedback from you, the professionals, you who are working on the ground in real estate every day, would be very useful in doing that. The next question I see is from Michael Beggs. Have all the parties such as trade, bell trade, income tax, tourism, consulates,
if they've been
consulted? I think this is part of what we're doing now. I think the first consultation that your association is seeking to do is within the body of professionals, so we can put together as good a draft as we want. You're going to put together your best foot, put forward your best foot, put together a draft, and then you're going to start sending that draft to the Ministry of Lands and other government agencies, tourist board, etc. At the same time, you may want to start putting out feelers to those bodies even before you have your draft, so that you can get some feedback. But my experience with those bodies, and then you've really just heard it from Ms. Cho, is they don't really pay much attention to it until you put a nearly final draft to them. They're not going to necessarily work with you piecing it together. Next question.
Yeah, certainly.
So number 5.
We're at number 5, yeah.
It's from Michael.
Regulating the actions of this part of
Read it all.
So this act should be regulating the actions and business practices of real estate brokers and real estate salespeople. You cannot regulate the development industry, as this will create unfair tax implications. With that we discussed that.
Again, it's not a matter of, for us, my opinion, I can't say what it will be in the end. And then knowing what the Jamaican legislation had, and the Jamaican legislation had an entire provision that deals with development. And Jamaica as a country, they have massive subdivisions. There's a lot of development going on. There's a lot of foreign direct investment. And what has happened with this piece of legislation is that section has been pulled out. So it's not a matter of regulating developers, but it's a matter of having something in the legislation that says how this legislation will treat and deal with developers. And then the other side to consider, this legislation has not spoken to tax implications. It has not sought to step on the toes of the tax department. All it is saying is that these bodies, these groups of people who practice as real estate professionals must meet a certain standard, and the only monetary provisions there are is that you will pay your application fee and you will need to get your educational requirements.
Exactly. It
So
doesn't go
as far as
into tax
liabilities,
implications, because that is the responsibility of and regulated and governed under the tax acts. So the legislation for professional bodies do not, as far as I know, do not mention or speak of tax implications. As Wayne said, it's simply, how do you qualify? How are you regulated? Not whether or not you pay taxes. That is up to the tax department to determine how they will deal with unfair tax implications, whether you're double taxed or howsoever. That's not what this legislation is for.
Next, Oscar Romero says, I believe there must be compulsory collaborative regulations pertaining to foreign brokers or agents to work with a licensed agency in Belize. I think that is sort of what this piece of legislation leans to without saying it directly. It's pretty much saying there's a lot of foreign brokers that come and work in or work out of Belize. And it's not saying, well, they're very heavily regulated in the countries that they are based in, but they're not regulated at all in Belize. I don't think the aim of this legislation is to say that they can't practice in Belize. I think the aim is to say, if you're going to practice in Belize, you're going to have to meet the Belize regulations. But as I said before, a lot of these agents may actually have qualifications that are over and above what would be required in Belize, but at the same time, that doesn't mean that you just come and not say to the local commission or the local board, here I am, these are my qualifications, here's my application, can I have a license, please?
Exactly. It's a...
Okay.
Can't hear you, Carlo.
Carlo, you're mute.
Sorry, guys. Yes, sorry, guys. I wanted to just note, and I'm really sorry, just because we have such a long list. We have someone that has been raising their hand, Ms. Lisa. So I will just unmute her. And actually, Ms. Lisa, I'm sorry about that. I'm muting you now. So you could please go ahead and let us know what your question is, Ms. Lisa.
Hello. Thank you. Can you hear me?
Yes.
Yes. Go ahead.
Super. Apologies. I came in late. I couldn't access it so easily, even though I registered. So I missed most of this presentation, but why I wanted to join, we have a coral restoration organization, Fragments of Hope in Placencia, and we've been here over 20 years, and we're very concerned about the offshore key development near Placencia, coastal development regulations that are not really being adhered to. And anecdotally, we know for a fact that the dredge operator here accompanies some of the real estate folks out to the Keys and tells potential buyers that they can just give them the money for the permit and they'll get the permits needed to happen. And I have so many different official reports to fisheries and DOE and geology and mines about dredging over the last few years. But even outside of those official reports, it's nonstop development with our inner Keys here. And so this has come up at some of our marine conservation meetings where we're always preaching to the choir. Thank you for giving me a voice, because I'm hoping that we could link with, I'm glad to see the real estate people are getting more organized. I know there has not been super organized. There's a lot of foreigners selling property here, and we'd like to see Belizeans take control over Belizean land, but we hope that there could be room for improvement with our relationships in the future, so that there are guidelines, to help guide real estate and developers on do's and don'ts, and what is absolutely not acceptable, what these types of things. And I don't see that guidance out there. And again, I'm sorry if I am offline with your part of your webinar I missed, but please include me on future ones, because we would like to engage, and I hope I speak on behalf on many partners, the Belize Fisheries Department, a lot of partners we have, a lot of NGOs, and we would really like to see a more unified effort with real estate agencies that are selling offshore keys and coastal areas, so that we're doing the right thing and we don't end up like the Yucatan in Mexico and the DR and other areas where it's just completely unchecked and detrimental to our reef health system. So thank you for allowing me to make that comment, and hopefully we can follow up later. I know you guys are probably just getting organized, so I'm not super familiar with the real estate places here, and frankly I have a bad feeling about, based on the Placencia area, I could call some names, but it's mostly foreigners. So I'm glad to see Belizeans taking charge, and I hope that you guys unify as Belizean real estate people and can do something about the unchecked wholesale sell of our natural resources. So thank you again for giving me that time.
Okay, sure. Thank you, Ms. Lisa. And feel free to reach out to us by email. It is definitely something outside of this scope, as you mentioned, but it does affect the industry and our country, and it is real estate. So please feel free to reach out to us by email or on social media, and we can have a different discussion about that. Thanks. Sorry about that. I think Wayne and Oneyda, would you? I think we were kind of rounding out some of those questions, and I think we're kind of winding it down.
We're seeing a lot of questions here, Carlo. We're trying our best to go through. We don't want anybody to feel left out. About how much time do you think we have?
Well, technically this session, the Q&A would be closed soon, but we had said that if people wanted to hang around, we would have allowed an open session.
Okay.
But at the same time, people seem to be hanging around, and I think they like what you have to say, right? At least they're interested in your input and your professional advice. So I would say, since people are still around, let's continue the Q&A and let's go down and see.
Well, the next question from Michael says, why is this act seeking to criminalize actions? This is a civil law. Fines acceptable for breaches followed by suspension. You need to soften the tone of business laws. And he goes on to comment on the low level that Belize is in ease of doing business rankings. I'd have to really answer that. I need to look back, because again, we said this legislation is coming from a long way off. Thinking of other professional legislation, they may not, summarily before the courts may not be the best place to handle it. A lot like with the attorneys, what happens is we go before our legal counsel, and our legal counsel itself has the power to suspend, remove our license altogether, fine us, or reprimand us. So maybe that section that deals with summary punishments could be put under the powers of the commission itself. But again, that comes from looking more at the modern legislations that have come out since, consultation with the government, how they'd want this to be treated. But regardless of whether it's dealt with summarily before the courts or before the commission, the end results and the penalties would be very similar. And I think really and truly for the public, going to the commission, as long as the commission is properly constituted and is seen as fair, it may be easier for the public to go before the commission to deal with their complaints than have to go with an overburdened court system.
Mm-hmm.
I think that's actually one of the, supposed to be one of the functions of a commission. It's a disciplinary body, supposed to act as some sort of tribunal for that.
Michael also goes on to say how are decisions made by the committee, votes how are minutes recorded for members to view. I'm sorry, somebody's mic is active, so it's...
Yeah, it's okay. It's muted now. It's muted.
Can you hear me, Carlo?
Yes. Yes. Someone else was on, but I muted it.
Okay, yes.
So, to answer that, the decisions of the commission are by a majority of votes. And in addition to an original vote, the person presiding at a meeting shall have a casting vote in any case in which the voting is equal. That is what is currently set out in the I guess the rules of the commission, the regulations for the commission. It says that the quorum, where is this, the quorum? I don't see the quorum.
But again, this being a bill, it's a draft bill. A lot of this is still up for formulation. And as we said to you when we met early, at the first time looking at this, it still needs to be fleshed out quite a bit. There's still a lot of detail that needs to be worked out into how the commission operates. Michael also says or comments, residency requirements and experience disqualify all foreign investor developers. I'd love to see Beltrade to explain that to an investor. Again, this goes to what we're speaking about with developers. And again, as a commercial attorney, a lot of my clients are foreign developers. I understand the concerns, but one, this legislation needs something in it to deal with developers. The other answer to this is if a developer has purchased land, is developing land, and is selling that land themselves, they may themselves come under the exception. Because again, they are selling it. So if you are a developer selling land that belongs to you, you are an owner, shareholder that is selling land and you fall with it, that you own, and you fall within the exception to that act.
That being said, in terms of the residency requirements, it does say citizen, Belizean citizen, and or have valid working papers. The legislation should actually mention under our CARICOM treaty, it's supposed to mention as well, instead of Belizean citizen, it's supposed to say CARICOM national. And apart from that, for other foreigners, having a valid work permit to fall under the scope or to be able to be regulated and licensed here in Belize. I mean, to work in Belize, you need to have a work permit if you're not a Belizean, or if you're not a resident. So it just goes with immigration and labor laws generally.
All right, Oscar comments that I think you're throwing a... Sorry, Carlo, go ahead.
Sorry, no, I just, because I know we're kind of taking a lot of questions from the same people, which are still good, but I had three here that came later, but I think are very easy questions to answer that I would just want to address quickly. Mr. Shepherd asked, how can you continue to submit other offers when you already have an acceptance? Are you implying that more than one offer can be accepted at the same time?
No.
I know for me, I think the thing is closing, right? It's before closing. So technically, if I accepted today and I said draft paperwork for next week and we didn't do anything, and then someone else comes tomorrow and says, I want to close now, technically they can still make that offer and close that before me because they have to close. I believe that is the sense of that, no? Then Ms. Morgan asked, when will we get to see an updated draft? Actually, yes, we had essentially been kind of promised a window of like early summer, which is like pretty much now, so like June, July, and If you guys were tuning in earlier, Ms. Cho, the legal counsel from the Land Department, had mentioned indeed that they do plan to still give us something around that time. So that will be the next draft, which we can then really kind of dig into more seriously as well. And then Mr. Augustine Hebert asked, what are the next concrete actions? And that would be essentially to put all of this feedback into this report we're talking about, and to submit it to the Land Department and basically work with them on the next draft, which is still not going to be final, right? But we're making progress. So the next step is actually more reporting to them, at which point they can then incorporate that feedback into their next draft. So that's our next steps. And then we will probably do another one of these if it's before, which I believe it will be, if it's still within that time period where people can't meet in large groups. Depending, but we will keep you posted on that, guys. With that said, I'll just turn it back over to you guys. And I think I just finished that. Thanks.
Okay. There's a question here from Kalila. Will the broker's exam be one already established for Caribbean countries, if there is one, or an American one? We don't know as yet. That is something that we thought should be specified. Honestly, I believe that the requirements for licensing or for being qualified need to be really specific, because right as it is a little bit too broad and very ambiguous. So it's not really clear as to what makes you qualify. It doesn't say what exam, what type of exam. It doesn't say what makes you a fit and proper person. It doesn't really specify any of that, and that gives rise to a lot of basically everybody would technically qualify if that's the case. So it doesn't really serve the purpose for which the legislation was drafted or is being drafted. So at the moment, no, there is no exam yet established where. Let me see here.
But that is something that we will be working towards, I guess, after we get, so I mean, that actually is the major concrete step after the passing, or actually during the passing of legislation, is that we will have to formulate the curriculum, I would say, and then obviously the exam. So that is something that will happen, and it will happen as a collaboration between private and public sector. So just elucidating on that.
Okay. Kalila also asks, that money being held sounds like escrow services. So at the moment, I believe some real estate agents, they hold money for clients. They don't necessarily use an escrow agent. The legislation actually provides you, if you're going to hold the money on behalf of a client, you will do so in an account specifically meant for clients, escrow funds, holding funds, whatever you call it, or you use an escrow agent. But as I said, a lot of real estate agents are acting somewhat in the capacity of an escrow agent by holding funds for their clients. But that needs to be regulated as well. There needs to be a way in which you deal with these clients' funds, so that it doesn't get tied up or mixed up with your own funds.
And actually, I'd say it is escrow services. The difference being, once you become a professional licensed body or a professional, you'd realize the banks and other public bodies recognize you as having that power to hold escrow funds. Attorneys hold escrow funds without it being a separate escrow service. As accountants, your certified professional accountant will hold your funds as escrow funds if they're paying over tax monies for you.
Because we're
and likewise, real estate agents, especially when you get that professional recognition, will be recognized by banks, financial agencies, FIU, as being perfectly allowed to hold escrow funds for your clients. Any other questions you want to?
If there's already corruption regarding land matters within the department, I do not think it is safe to have personnel from the department mandatorily sit on this board. There are other Belizeans who are skilled and knowledgeable enough to be chairperson of such board, etc. I think that goes with what I had said earlier in terms of reviewing what the composition of the board is. My view is that yes, there should be a head of a government, a relevant government agency to be part of the commission or part of the board, but not necessarily the chairperson. It should be, as Carlos said, more mandated by you guys as the professionals, as the licensed professionals. You guys should have the voice to say, okay, who will sit on that board? It should be some sort of an election, a democratic election to who will sit on that board, not just a simple appointment just because.
And it goes to your strength as your lobby. This is why it's good to have the numbers here, because these legislation, these laws have to be passed by government. So you're going to have a very hard time trying to pass it without putting any government members on the board. But the thing is, if you have a strong enough lobby, you can say that the real estate professionals need to have the greater level of representation on the board. If you leave this legislation for the government to pass it on their own, I can promise you that what you're going to have is a board that is pretty much overloaded with government representation, and the government would pretty much control all aspects of the real estate profession.
Yes, indeed. Thanks.
That being said as well, I think that is why it is also important for you guys to have, currently have two associations. One of the things that the legislation doesn't really mention or speak of is an association per se, or a mandatory membership to an association. I don't believe that we don't believe that there should be a mandatory requirement to be part of the association in order to be licensed, as I guess that's your choice. But the benefit of being part of an association is having that ability to lobby for change, being, I guess, elect people to be on the commission. Doing all of this is because you guys have an association, because you have somebody or people who want to see change to move forward. So although it's not necessarily in the legislation, it's still very important, just as a side note, to have associations, active associations, to lobby and move forward. Let me see here. Do you see any other questions?
A lot of the questions are dealing with details that we've already said it's a draft bill. There's a lot of details left to be worked out. So those questions relating to details of the commission, of the composition of the commission, the term of the commission, I think they're very good to be taken under advisement and just to make note of them, so that when your association is putting together its draft, it can use these suggestions that are coming from these comments in building out your next version.
Mm-hmm. I see here that Oliver says we need professional conduct, which the Act will address, but we don't need layers of regulations and costs that drive away investors, both Belizeans and foreign. I think every professional body, for us to be licensed, we need to pay to be licensed. Attorneys, architects, engineers. There is a cost attached with being a professional. It's part of doing business. So you can't say that, yes, you want regulations, yes, you want a commission, yes, you want this, and yes, you want that, and not have to pay for that. It's part and parcel of being a professional and being in a certified profession, having to pay and make, I guess, renew. I'm not sure how, it doesn't specify. I think it was every 3 years. Your license is valid for every 3 years. and you can renew it for further periods of 3 years. I think, sorry, what session? That's it? I think there was one other question. Is consideration needs to be given to grandfather certain businesses and practitioners at the time of passing the legislation, also time frame given thereafter to meet certain continuing education. I don't think that's really in the legislation yet, but that is something to be considered in terms of how persons already in the profession would, I guess, what type of, that goes with the exams, what type of exams and continuing education that they would have to do in order to qualify. So I guess that's also something that needs to be considered as well. Okay. All right, I think those are all the main questions. Is there any?
As Carlo wants us to address anything else.
Do you want us to address anything else? Anybody else has any questions, concerns, clarifications?
I don't see any hands up, but we do continue to get, I guess, small questions. Someone just asked, Mylan asked, who all are part of this committee in putting this draft bill together. And so I just noted, and actually I kind of mentioned it early on, but you know, we want to hear from you. So I mean, it's no secret. So what I would say is, if you're interested in pushing this thing forward, we're very interested in having you. We really need more professionals to kind of get behind this and push it. So I would recommend to people who want to be on a committee, they can email us at info@belizenar.org. They can sign up to be a member, and then they can also join then a subcommittee. And we do have a legislation/advocacy committee, which is geared towards this. We have other committees too. So if it's other things you're interested in, like networking, for instance, education opportunities, these are other committees that we have. So if you guys want to be a part of the association, please reach out to us, info@belizenar.org. And we'd be happy to give you more information, give you the packages, let you know how you can join, how you can be a part of this, and how, you know, we can all work together to push this thing through. What I'm seeing today is very encouraging. I'm very happy to see that there's this many stakeholders that are interested, you know, in the future of their own industry. A lot of the comments, again, are very similar to things that we had already proposed, so they're not really a surprise to me, but it's really good to see that we're on the same page in a way. So I want to thank everyone for their comments. I want to also, I think there was one question that was kind of late too, right before this young lady, Miss Mano Mazella asked if certification for brokers, or she said it seems to be all over the place, and asked about a school. And I just wanted to iterate that there's nothing yet, but with the passage of this bill, there will have to be a proper real estate course and licensing exam. Not yet, but that will be a part of it. And to the next part of her question, which is some older brokers might have made themselves up and they don't have a diploma in the broker sector, so they have to close business or just get a validation with a test. This kind of comes back earlier too to what Ms. Ayala was asking about grandfathering. Some people are interested in having a grandfather process where people who have been in the business for a long time can just kind of be ushered in. I won't say I'm against that, but at the same time, we have to see what the industry as a whole thinks. But me personally, as a broker that's been in the industry for about 11 years, I have no problem taking the exam again. So I don't see why anybody else should have problem taking the exam. So to answer that question, worst case scenario, everyone will have to take the exam. And I don't think any professional should have a problem taking an exam. That's my thought there. And I think that's about it. I think Van had also mentioned some things, and I asked him to please touch base with us and maybe send us some of his more local information from the US that might be able to kind of input into this. But yeah, I think that is it. I want to just say, I mean, I don't know if you guys have any closing remarks before I officially close out.
Not really. It's really, thank you so much, Carlo, for inviting us to actually try and assist in this venture. As we said at the start, we recognize it's a working draft. We didn't have much part in it, but what we are, well, any part in it, what we are trying to do is to break it down into simple language that is not legalese so that it would encourage this kind of discussion. So we're happy to have started the discussion. You know, we'll continue to make ourselves available to try and continue the discussion and to try and get this as far as it can go.
To participate as much as possible as well.
And I recognize, I just had in my notes here some of the key things even before the question and answer section started, that composition of the commission itself needed to be strengthened. The regulations, the code of conduct, it seems to be all over the place. It needs to be tightened up. I'm happy to say that from what I've seen, it does not seem to step on the toes of the FIU, central bank, income tax, or any of the independent real estate associations. So it really strictly tries to stick to licensing and standards, which is very good. But at the same time, as was recognized in some of the questions, the licensing requirements, as they are right now, they're very vague and need to be tightened up before you get anywhere. You don't want to have a commission that has a blank slate to do whatever it wants to do. You want very simple, and as somebody said, not multi-layered, but one layer of regulations, and then the commission takes those very standard regulations in going about their business. Mm-hmm. So with all that said, and with the conversation started, I think this has been very productive. And again, we thank you for having us.
Thank you.
Thank you guys. Actually, we owe you such a debt really of gratitude. The BNAR, first of all, for having you assist us in this manner, because, you know, we don't want to put anything out there that is not express legal advice. But no, I just wanted to thank you guys really for taking the time, not just today to explain to our professionals, but taking time to analyze it. And I think through that you have found what everyone else is seeing here is that there's a lot of work to be done. So with that, I want to close it, and I want to thank you again for your willingness to continue to help us in this push. I want to thank everyone that participated actually as well, because really without you guys, it doesn't work. And so for me, the only way our industry can move forward is if all the players decide that they are going to push this thing and that they're going to play. So with that said, we want to keep you guys engaged. Feel free to reach out to us by email. We will be sending out this report and this webinar as well that you can take a look at your leisure if you want to go over it and, you know, see if there's anything that you missed. I want to thank one more time just special guests that we had as well, which is the FIU, the Central Bank, and the Lands Department. Thank you for giving us a little word there, Ms. Cho, as well. So with that said, I'll wrap it up. Look out for a report, guys. Look out for some emails coming. Please stay engaged. We're really happy to have you, and we hope that we'll all be pushing together on this bill and that we can get this thing out the door by the end of the year, right? So thank you all so very much. What I will do now, I will just go ahead and mute myself and I'll stop the video. And if you guys want to continue to chat amongst yourselves in the chat, we will leave that because we have a good collection of professionals here. So if you guys want to kind of continue to have an open discussion, I will now leave the forum open for that, right? But as far as our recording and our webinar goes, we are done, right? So thank you guys once again so very much. Really appreciate on behalf of the BNAR, our board, our committees. Thank you so very much. Thank you to our attorneys at law. Thank you to our guests. And please stay engaged, guys. Have a great weekend. Bye.